the ongoing litigation against Illinois' gun ban now going up to the U.S. Supreme Court, with several cases asking for them to hear the challenge to Illinois' gun and magazine ban. You've got the Southern District of Illinois continuing on with the challenge there. In 4 plaintiffs groups, they've continued forward dealing with the merits of the issue. You've got a status hearing that's set for the 28th, where attorneys for the plaintiffs are going to go through and they're going to take a look at what kind of evidence and testimony and witnesses and the like they're going to do as they work towards discovery. Of course, Judge Stephen McGlynn down there in the Southern District has said that they are not going to delay this any further. They're going to get to the merits of this case, and we see that timeline working out here. But all of that, of course, was dealing with like the Second Amendment questions. But if you recall, Thomas Magg, the attorney for the Langley plaintiffs, he challenged the law not just on the Second Amendment, he also challenged on the 14th Amendment vagueness and also the Fifth Amendment challenge. And we've tracked the Fifth Amendment challenge on the merits, where the plaintiffs, the Langley plaintiffs, are asking for summary judgment. And if you recall, earlier last month, the state did respond to the Langley plaintiffs. And let's just review that here, because here with Bishop on Air, we've been tracking how this happens. And of course, I hope you like, subscribe, and hit that notification bell. If you want to support the program, I'm just doing this in my own home. You can buy some Bishop on Air merchandise, coffee cup, sweatshirt, whatever the case may be. But we've been tracking this, of course, and all the different ins and outs of the state trying to dismiss the Fifth Amendment arguments and the court saying, no, we're moving forward with that argument. They even had a hearing on the vagueness issue, if you recall, but the judge did deny that motion to find the law unconstitutional on vagueness grounds. So now we're on the Fifth Amendment challenge, and the states responded to Thomas Magg last month. Let's pull that up so you can follow along here. And just to kind of review some of the overview here in the introduction, they say in their 19-page filing that the endorsement affidavit is not directed at the criminality of the suspect and does not compel a confession of criminal activity. The endorsement affidavit does not compel or coerce any testimony, and the possibility that plaintiffs will be prosecuted based off their endorsement affidavit is not real and substantial, and plaintiffs should not be granted leave to add a new due process claim. So that was what the state ultimately said in their filing, and you go through and you find out that, for your call, the state did say that it is not against the law to not file an endorsement affidavit, and that is, of course, the registration of banned firearms. So the state made that case, and all while we're looking at that, you've also got the latest numbers of the gun ban registry not being updated, and just doing a refresh here on that page from the Illinois State Police, how many people have actually registered firearms. And it hasn't been updated. Still stuck there at the most recent update from January 31st, where an additional 6,200 on top of the 29,000 have registered of 2.4 million firearm owner ID card holders. So you have that still out there. So the state's saying that, the Langley plaintiffs should not be able to have their argument be sustained. They talk about, responding to Haney's v. United States, which is a Supreme Court precedent about the Fifth Amendment. Oh, and just for those who don't know what the Fifth Amendment is, the Fifth Amendment is your right to not incriminate yourself. It's your right to not be compelled to speak in a manner that's going to possibly leave you open to criminal liability. So the argument is that the Fifth Amendment right precludes somebody being required to file an endorsement affidavit. So let's get to, I guess what the state's response to was that, if you recall, they ultimately just boiled it down and said that from their understanding, it doesn't compel people to do this. It's merely a suggestion, an easier way for individuals to keep and have those grandfathered firearms legally. So you've got, again, let's check out what the state had to say here. An endorsement affidavit identifies the weapon and affirms that the individual owned it before January 10th of 2023. The exemption recognizes people who lawfully possessed assault weapons before this date have a reliance interest in retaining possession of items legally acquired before such acquisition. Meanwhile, the state's interest in reducing the number of assault weapons in circulation could be accomplished by restricting the sale, purchase, and possession of new ones. Thus, it reflects the legislative compromise, promoting both the reliance interest of the law-abiding gun owners and the legitimate governmental interest in reducing the number of mass shootings. Again, just a little bit of insight into what the state is thinking when they responded to Thomas Magg's filing on the Fifth Amendment. Well, earlier this week, Thomas Magg filed the response to the state's response, and here is how that reads out. It's about 20-some-odd pages with several attachments to it. But it says, come now, the Langley plaintiffs, by their own attorneys, Thomas Magg and Magg Law Firm. And the introduction spells out, as attributed to the American philosopher George Santayana. I'm not familiar with that. Those who cannot remember the past are condemned to repeat it. Familiar with that quote, though. It goes on to say that in drafting the so-called Protect Illinois Communities Act, the proponents of the same were in such a hurry to get the statute, in fact, any such statute, on the books that they utterly ignored the Illinois Constitution's 3 readings requirements. The requirement designed to slow the passage of legislation to improve its quality fell into a trap that, had they spent a week or two researching why prior firearms laws have been declared unconstitutional, might have avoided this issue instead. Like the Light Brigade, they rode headlong into the valley of death for statutes well guarded by Haney's and its Fifth Amendment. Similarly, the defendants were so desperate to respond to the Fifth Amendment issue that it literally argued a summary judgment motion without a single document, affidavit, or attachment attached. Then it goes through the facts. It says the simple fact is that PICA purports to require ordinary persons, even today, who possess unregistered PICA-regulated firearms to register them. The ISP on its own webpage states, failing to comply and submit the required endorsement affidavit while in possession of items regulated by PICA prior to January 1st, 2024 is in violation of Illinois law, specifically the FOID and the Criminal Code of 2012, unless the individual is exempt. Sentences range, and it spells it out. A person who violates these requirements may be arrested and charged. Well, again, before the January 1st deadline, right? But we have people who have registered firearms after that January 1st deadline. In the whole month of January, actually, you've got 6,226 people who registered after that January 1st deadline. Back to the argument that Magg's making here. This is the exact situation that existed 61 days after the enactment of the original 1934 version of the the Federal Firearms Act, the NFA. Regulated firearms to be registered with the IRS within 60 days of passage. As stated in the Seventh Circuit of the original National Firearms Act, registration would be an admission that another section or other sections of the act have been violated and might support the conviction by a court. Likewise, the Seventh Circuit also stated, we do not think that the fact that there might be cases where registration would not result in incrimination by the registrants is any answer to the contention that one who's required to register might thereby incriminate himself. Magg's argument filed this week goes on saying that defendant argues about past conduct and incrimination. What past conduct can registration affidavit, an Orwellian euphemism for a firearm registration form, provide that might incriminate the registration? How about the most obvious? The same situation that existed under the National Firearms Act and ruled on in Haney's. Just like in the NFA of 1934, which required registration within 60 days, all persons in Illinois who possessed PICA-regulated firearms are supposed to register their firearms, 50 BMG ammunition, and accessories on or before December 31st. Possession of these PICA-regulated items after December 31st, 2023 is, drumroll, interesting to see that in a legal document, a crime. Do not take plaintiffs' or their attorney's word for it. Look at the defendant. Kelly himself says that it's posted on the website with an exclamation point there. So again, you've got them spelling out all of the different frequently asked questions that there are, seeming to kind of go contrary to some of the language that we used in the state's filing. So you've got the voluntary benefits that the state argued. Defendants first argued that its registration provides a voluntary benefit to the registrants that exempts owners from criminal prosecution. This is simply untrue, Magg says. And as shown above, defendant's own website admits the prosecution authorities they may consider late registration insufficient to avoid prosecution, coupled with the fact that, as noted in the ISP, has provided and will provide the information to every law enforcement agency in Illinois. There is no benefit to registration at this point unless the registrant was previously exempt. All a late registration does is admit the person filing same committed a crime. So again, it goes on to spell out and to counter a lot of what the state said. State said that no one's compelled. They say that that's a falsehood in the sense that no one is ultimately compelled to continue to breathe. The statement is literally true. But just as failing to breathe has obvious consequences, so does failing to register a possessed PICA-regulated firearm under PICA. Assuming no exemption, there is a criminal penalty as set forth, and it spells out the law. It says a person convicted of failure to possess a FOID card is required by Section 2 of the Act, or complete an electronic endorsement affidavit is required by the section, commits a Class A misdemeanor or Class 3 or 4 felony. So we've covered all of that as well. So interesting to see some of the back and forth here from the state and what they're having to say versus what the plaintiffs are arguing. So you've got the plaintiffs saying that they need a ultimately summary judgment, which is a final definitive answer on this Fifth Amendment question. So that's ultimately the conclusion here. To the end, plaintiffs renewed their request for summary judgment in their favor of the self-incrimination Fifth Amendment issues and joining defendants and those acting in concert with or under the authority of defendants. So there you go. The latest in the Southern District, just with the Fifth Amendment arguments, right? So summary judgment being requested. When we'll see summary judgment on this, unsure. But we know that the overall case with all four plaintiffs groups going forward in Judge Stephen McGlynn's courtroom in the Southern District of Illinois with the status hearing set for February 28th. So that's just in less than 2 weeks here. So we'll be watching all of that and updating you each and every weekday morning here with Bishop on Air. Greatly appreciate you guys being here. As always, be sure to like, subscribe, hit that notification bell, and join me around this time each and every weekday morning as we break things down. Appreciate all of you guys, and we'll be back with more. As always, stay tuned with Bishop on Air.